Well, good afternoon, everyone. Welcome to another edition of Free CLE Fridays with Wilmick. We're very happy to have you with us on this beautiful day. Nice for you to give us an hour. Hopefully, we'll give you an ethics credit and some good information that you can take back and use in your practice. Just a reminder, so you are on a YouTube channel watching us. There is not a mechanism for non-YouTube members to chat with the speakers, submit a question. But if you do have questions or comments and you would like to submit that to our speakers, just email me. It's tom.watson, WATSON, at wilmic.com, WILMIC.com, Tom Watson at wilmic.com. If you email your question or comment to me, I will get it right up on my screen and I will forward it over to our speakers today, and they will be able to address that for you. So that being said, let's dive right into it. We've got an hour, and one other reminder, this program has been approved for an ethics credit. So you get a free ethics credit today. And when it comes time for you to report, when you go on the BBE website for reporting purposes, you'll want to click on the live webcast button. That's the button, live webcast. When you do that, this program will show up on September 17th. So there you go. All right, so let's get into it. Our speakers today, Matt Beier, claims attorney at Wisconsin Lawyers Mutual Insurance Company. Matt's been with us for 5 years. Also with us, speaking with Matt today, Brian Anderson. Brian is our senior claims attorney. Brian has been with Wilmick for almost 18 years, since 2003. So Matt and Brian are here. Joe McCarthy, Vice President of Claims and Underwriting, is with us as well. And if warranted, and he has some contributions, something to chime in with, or you have a question for Joe, by all means, fire away. Joe has been with Wilmick for 10 years. So lots of good claims and underwriting experience. So take advantage of these guys, some good resources for you. And if it's a question maybe that's not quite on the topic, that's okay too. Since Joe and Brian and Matt are here and have that wealth of knowledge, anything that's on your mind, please feel free to throw it our way, and they'll talk to you about it. Again, submit it to tom.watson at wilmic.com. All right. That being said, let's get it going. I'll throw it over to you guys. Good afternoon, Matt and Brian.
Well, good afternoon, and thank you everybody for joining us on this September 17th. It's a beautiful day out, and I was just sharing with Tom that I was able to watch my son this morning. They had a fun run outside, which was it was just fantastic weather. So hopefully you're able to join us by this virtual seminar wherever you might be, that you can enjoy that kind of weather on your front porch, on your back porch, wherever. In any event, thank you for joining us. We're here to talk about, and we've titled this program, Plaintiffs' Personal Injury Practice, Understanding the Risks and Avoiding the Claims. Plaintiff's personal injury it's always a timely topic. At Wilmick, we try to bring you, based on what is currently happening in the claims world and in risk management world, things that are timely. And it just so happens that this one is an old standby. Because plaintiff's personal injury practice is one of those practice areas that is perennially at the top of the list when it comes to frequency and severity in claims experience with Wilmick's insureds. As we have some statistics there for you in your outline as an area of practice, we have about 15% of our claims, and that's almost always in the top 5. And that's by way of frequency, and then severity. 30% of our claim dollars, money that we spend to resolve claims, is again at about 30%. And so again, that's also usually in the top 5. So we have a list of errors there that are most frequently made. Calendaring continues to be problematic, not ascertaining correct deadlines specifically. Inadequate investigation or discovery, and failure to inform clients. So those areas we'll get into in a little more detail a little bit later in the program, and I'll ask Brian to elaborate on some of the specific kinds of claims that we see and how we can avoid those kinds of things. But I'd also like to take a moment and step outside the outline and talk about the elements of legal malpractice, something that we usually cover in most of our programs and we think are important to share with all of you. So what are the elements? Well, when we're talking about malpractice, there are generally two theories that can be pursued. One is a tort, and that would just be straight negligence, and another would be a breach of contract. For the purposes of our conversation today, we're going to focus on the tort of negligence, and we're going to talk about those elements, those being what we all learned in our Torts 1 class in law school: duty, breach, causation, and damages, with a couple of twists there. So first twist, and one of those things that has to exist anytime a claim of legal malpractice is asserted, is the existence of an attorney-client relationship. Privity is required for the duty to even trigger in the first place. Now, although the plaintiff has the burden of establishing that an attorney-client relationship exists, be careful, because most courts, will, in the absence of anything written down, will weigh heavily in favor of the client or the purported client, however it may be. So the client's subjective belief about whether or not an attorney-client relationship exists is something that would prevail over the lawyer's subjective belief. Right off the bat, as far as a risk mitigation approach is concerned, make sure that you write your engagement letters when you're required to do so. I think more often than not, I can't think of situations in which a plaintiff's personal injury claim would be pursued without a contingency fee agreement. Those have to be in writing. They have to be signed by the client. So make sure that that's clear, that there is or isn't an attorney-client relationship and what the terms are if there is one. Hand in hand, I guess, goes the non-engagement letter, so that if you do have that conversation with a client or a potential client and you decide not to take the case, at Wilmec, we like to say that no is a complete sentence, but it's always better to follow that up with a non-engagement letter. You came, you talked to me about this. I offered you no opinion about it, and I declined to take the case. Make it a 2-sentence letter, short and sweet, but clear up any confusion that might exist as to whether or not that attorney-client relationship exists. With respect to negligence itself, the duty.
Before you leave the attorney-client, it seems like it would be obvious that you either are retained or you're not. Unfortunately, over the years, we have seen more than I can count claims where the attorney was not sure they were retained. They were going to look at things. Maybe they talked to someone on a weekend, or someone dropped off records when they weren't there and they're sitting in the office. The attorney never got a chance to look at it. And unfortunately, the mere fact that you don't have a formal retainer letter doesn't mean you're not on the hook if the statute expires and you have control and custody of the client's file. And that I'm seeing that as a warning, because often it can be traced back to an informal retention situation whereby the attorney wasn't really retained. Someone was in there and dropped off some records, maybe a staff member's spouse, whatever the situation may be, never got a chance to really formalize any retention. And I think it goes back to, Matt, your point about just say no. Be cognizant of the fact that you are at risk if someone thinks you're going to look over their materials. You haven't even agreed to take the case yet. And in your mind, you're going to look at it, you're busy, but that's where you have to say, and it sounds cold, and I realize it sounds unfriendly, but to say, listen, I can't even take a look at this right now. I'm tied up, I have a trial. I'd be happy to, if we want to sit down and talk about a retention, we can do so. But be careful about being friendly and nice and then have the clock tick to the 11th and 12th hour when you haven't even had a chance to look at something. Because unfortunately, you will be on the hook if you had the opportunity to either file a claim or refer them within the statute period and the file was in your care and custody and control at the time that when the statute expired.
Yeah, that's a great point, Brian. And, throughout this presentation, we'll try to chime in with, effects that we have seen from the pandemic. little bits and pieces of everybody's practice have changed along the way because of the pandemic. One of those things may be how you deliver and receive materials from your law office. And so if office hours are reduced, for example, and there's a drop box or there's somebody else picking up mail or deliveries, that can be problematic. So be sure that you're aware of whatever changes have been made and that you're regularly reviewing documents and mail and any sort of deliveries, that come by way of your office, so that something doesn't get missed. And the very situation that Brian just described, where the potential client drops off materials, thinking that, you are his or her lawyer, and you're not.
Yeah, it kind of
misplacing those things.
Yeah, it really falls back to the cocktail advice or the backyard barbecue, whatever but the problem there, one other, I don't want to overstate it, but it's important because it's very frustrating for us and the attorney when the claim comes in. Is you're maybe even better is that you're saying, I'll look at it. When did you say this accident was? Okay, 6 months ago. All right, I'll take a look at it. We have 3 years. Well, until you dug into the file, you didn't realize it was a claim against the municipality or the state, or maybe it was a claim that wasn't in Wisconsin. Those type of little nuances that greatly affect the, you don't have 3 years. You may have 6 months to make a notice. So it's just a cautionary note about making sure that you have a formal retention and engagement process that you can vet things properly so that you're not exposing yourself unnecessarily to a risk.
Yeah, absolutely.
See, there's something in the chat. I don't know if that's
in ours?
Oh, okay, never mind. Yeah, it was my personal chat saying shut up and keep. No, I'm one piece of background. I've been with Wilmec for a long time, but immediately prior to joining Wilmec, I was handling with a plaintiff's personal injury firm. So don't act like if you think I'm trying to sound like I Mr. Know-it-all. No, I'm just reflecting on every mistake I made for the last. We were a high volume plaintiff's firm, and best practices sometimes are. I want to just get it out in the open. The time pressures were incredible, and I was trying cases and running all over the state. So don't think that I'm saying on a soapbox. I'm just saying that from the hindsight vision of a Wilmec person, and having practiced, I bring these examples to you with the full hope that you can avoid being in a claim, but I'm not in any way failing to understand the pressures and the time crunch that accompanies this area of practice.
You bet. And so, let's move the elements along here. We talked about the attorney-client relationship and the importance of following up with the engagement or the non-engagement, perhaps more importantly. Negligence, what is the duty and how do you establish as a plaintiff, that breach of that duty? Well, we have case law out there, and I can offer a couple of cites real quickly. Lewandowski versus Continental Casualty, 88 Wis 2nd 271, and Estate of Campbell versus Cheney, 169 Wis 2nd 399, for a discussion of these elements that we've been talking about. But the duty and the breach of it, more importantly, has to be established by expert testimony. In other words, you've got to find another attorney who identifies what the duty is owed to the client and the fact that it was breached. We've won several cases, good, bad, or otherwise, based on, that very requirement, where we'll face pro se claimants who simply don't understand. To them, it seems like, oh, well, the error is so obvious. That can be an exception to the requirement of expert testimony, but more often than not, judges will find that, no, you need expert testimony. You need to offer an expert who will identify what the duty is and why it was a breach. And so the failure to produce that expert can result, that can be fatal to the plaintiff's claim. But I mentioned one exception, and that is that the error was so obvious. For example, a statute of limitations that has come and gone. That is something that may be obvious enough there can be nuances and differences in that. Brian mentioned, when it's a claim against a municipality, that changes things from the usual statute of limitations for personal injury actions of 3 years in Wisconsin, to 6 months notice of claim and every other part of those statutes that apply to municipalities. But in any event, when it's clear that there's a blown deadline, maybe you don't need an expert, as long as that's the error that actually caused any harm, which I'll get to in a second. It can also be that, you, the attorney who has either been accused of committing an error or feel you have committed an error and you admit that you committed an error. That is something that doesn't require expert testimony to establish. That doesn't mean that you don't also have, a duty to communicate to a client something that has gone wrong in the case, but does it necessarily require an admission on your part? That's a time to pick up the phone and talk to your claims attorney, and perhaps get counsel involved, to make sure that those things are worded properly. And then, so that's the duty. That's how you establish it. And the duty itself is to render legal services and exercise that degree of care, skill, and judgment, which reasonably prudent lawyers practicing in this state would exercise under like or similar circumstances. And I believe we have the citation to the jury instructions regarding legal malpractice in your outline. But those are the Wisconsin jury instructions, civil 1023.5. And I do want to mention one thing with respect to the duty that a lawyer is held to when facing a legal malpractice claim, and that is that it can be slightly modified if the lawyer holds him or herself out as an expert. And I believe we have that case in your outline too, and that is Duffy Law Office versus Tank Transport. And so the duty is slightly modified to include not just what a reasonably prudent attorney would have done under the circumstances, but someone who holds himself out as a lawyer who specializes in this area of practice would have done. So should that be different? Probably not. But can it work against you? Yeah. If you hold yourself out as a specialist in personal injury, chances are that duty is going to be slightly higher. So Brian, anything that you want to add on the definition of the duty or the breach of the duty and the requirements that a plaintiff faces in bringing such a claim?
Oh, it's a pretty clear-cut area of the law in that regard, in that in the formal retention, if a statute expires while the claim's in your province and you haven't either settled the case, filed suit, and or referred the person to someone else, they're going to overcome that hurdle easily in the bodily injury, personal injury plaintiff case. So that's why the vetting, and we'll get into that a little bit more, but that's why the vetting and decision to take a case or not is important, because although the case is not supposed, we'll get into the case within the case analysis, from sitting from this standpoint on the claims desk, I can tell you that when these cases, sometimes the best friend is the fact that it became a legal malpractice case because they had some real problems with the underlying case. But it's enough. There's a risk involved, and there is liability clearly, and therefore they have an actionable legal malpractice case, which is it's such an aggravation for the attorney and the company, because you're talking about, instead of getting a fee, you're looking at paying a deductible, and instead of a happy client, you got an angry client. You're spending time getting deposed. So it is a risk once you make sure you're taking on the cases that you want to take, and understanding that if it's a really weak case, that's something, and you don't think you can do anything with it, cut that off earlier than later, or don't take it at all, because they're going to be able to establish negligence if it's not timely pursued.
Well, and that's a good segue into the next two elements: approximate cause and actual collectible damages. And Brian mentioned a case within a case, and what we often say is that, the case doesn't get better just because a lawyer, committed some kind of an error. And what Brian is getting at is that, the case that came in that was sort of garbage and got neglected on the lawyer's desk, and wasn't really going to go anywhere, or was going to result in some kind of a small settlement, but somewhere along the way, $100,000 demand or something bigger was made. The client, if we haven't managed the client's expectations, is expecting $100,000 to come in the door. And if an error is made that, sort of shuts the courthouse doors on the plaintiff, the plaintiff is going to look to the lawyer for that sum of money. When in fact, it may be that case wasn't going anywhere. It wasn't going to settle for much at all, but the demand had to start somewhere. So, all of that is to say that if a legal malpractice claim is pursued, the plaintiff has the difficult obligation to establish that the underlying case had merit and would have resulted in some kind of collection. But for the attorney's mistake, that it would have been collected no matter what. And that's a difficult threshold to meet. The case within a case is a difficult standard, and legal malpractice cases simply aren't easy. So knowing that and knowing that, there are several good defenses to legal malpractice claims, still keep in mind that, they're very thorny. And so they bring in a whole different set of dynamics, including a lawyer's reputation, another insurance company, and all kinds of underlying litigation that still has to take place. So I'm going to pause there, and I see that we have a question about the case citations a bit earlier. If anybody has those kinds of concerns, obviously, I will just feel free to bounce me an email real quick, and I will get you those citations so that you have them in accurate form. Go ahead.
I was going, are you taking those now, Matt, or are you taking a pause for me to blabber about something?
No, just a pause about, feel free to email us and we'll get you detailed information about citations.
One thing, there was a magic act that happened. My video stopped and the curtain behind me got shut, so I'm pretty good with that. But
wow.
But I wanted to say,
and Matt, just a reminder, your email address for the viewers who want that case citation.
You bet. It's Matt, MATT.Beier, BEIER, at Wilmic, WILMIC.com.
Matt touched on an important thing where it made me think of a bad claim we had that shouldn't have been, because it is what it is. I mean, in the end, you feel horrible, you missed a statute, but it doesn't make a $7,500 case $750,000. I mean, it is what it is, kind of thing. But one of the things I think is important to note, because we had a claim that became much more thorny because the staff, unfortunately, the staff at the lawyer's office was afraid of PI practice. Often in a bigger firm, there is a lot of paralegal involvement. If you have the luxury to have a staff, sometimes they're the ones that are tracking the medical treatment and the client's condition. So when the case is, quote, ready to move forward towards settlement, i.e. the person's done treating or you get a final report, then it goes to the attorney's desk to move forward. Well, in this instance, the paralegal had the case and recognized that the statute, she blamed it on herself, had expired, and was didn't know what to do, afraid to tell her attorney. So she carried on a fake communication with the client whereby negotiations were taking place. I know it sounds bizarre. Unfortunately, it was misrepresentation to the highest level. In the end, it was going to fall apart because she didn't have the personal cash to settle the case. There wasn't a great thought process going on, but I remember at the deposition, she said, in the end, why was that going on? The real answer was she was afraid she would be fired and didn't know what to do. So just a second, we always try, if we get a nugget or two out of this, make sure you advise your staff about your policy deadlines. I mean, this is going a little off field, but it is relevant here because that took a really marginal injury case and made it much more difficult and much bigger because there's misrepresentations going on, and it just looked terrible. And in the end, it was just a staff member not knowing what to do and was afraid they would be fired. So had it just been simply quickly reported to the carrier, we would have worked out a fairly nominal settlement because that's all the case was worth. But be careful with deadlines. And I know I'm jumping a little bit ahead, but I think it dovetails into the case within the case. Don't make it a better case because there's a misunderstanding about how to report things and or jeopardize coverage with your malpractice carrier. In this case, Wilmick, because you need to report things during the policy period. And sometimes I think the lawyer understands those, but maybe the staff doesn't, and it's worth, and or maybe a new associate maybe not understand that. So it's worth the time to talk about that, understand the dates, who the carrier is, and what to do if there's a mistake, so that you can just, that's why we're here, and that's why you have coverage, so we can work something out without all the thorns attached. And it was a bad result based on a misunderstanding about what would happen if and when a mistake was made.
You bet. The last thing that I guess I want to cover before we get into some more nuts and bolts is the statute of limitations as it applies to legal malpractice claims. The statute of limitations can be found in Wisconsin statute section 893.53. And in 2018, we were lucky enough to have that shortened from 6 years to 3 years. However, there are cases out there like Bleecker v. Cahill, and I will include that in anybody who asks for citations, talks about what is known as the discovery rule. This is less problematic, I think, in Brian, correct me if I'm wrong, but I think it's less problematic in personal injury actions because any injury due to error by the attorney, any injury to the plaintiff is probably known shortly after or during the outcome of the litigation, and so that 3 years actually has some meaning. But the discovery rule is what it is, and that is that if again, from the perspective of the plaintiff, if the injury isn't discovered until a later date, then the 3 years doesn't start ticking until that discovery. So until the injury is discovered or should have been discovered, the 3 years does not start on the clock. So just be aware of that and understand that these things can hang around. They don't always, but they can. I think Wilmick is dealing or has dealt with a claim that was about 25 years old from the date that the error was committed by the attorney to the time that it was actually discovered and reported. So that's my only note on statute of limitations. But
Matt, the case I was just mentioning is an example of why you don't want a staff member. All you're doing at that point is extending the statute of limitations because the client didn't understand that the statute had been missed in the first instance. So the discovery rule extended that. One of the first communications of date's been missed, be upfront, and we suggest you contact us, but the contact needs to be with the client. So not just to start the clock ticking on the SOL, but but that is an offshoot of it. They're advised of the mistake. They understand the date, their options going forward, the right to counsel. And there's no question then that the statute has started running on the legal malpractice case then when they've notified of the error.
Yeah, absolutely. And, Brian, that's a good point. And I'll just make one last one, I guess. We talk about communication on page 2 of your outline, and it requires lawyers to keep clients promptly and reasonably informed and shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding representation. So oftentimes, in the situation like Brian just described, hey, we've got this error. What do we do? How do we communicate with the client? That's a difficult communication to have. I usually start my response to those questions with, as the lawyer, you've got to communicate the good and the bad and the ugly to the client. And I would put this one in the last category, where, if there is an error that affects the outcome or the ongoing representation, that is something that has to be communicated to the client. And again, great opportunity to open up a line, if you haven't already, of communication with your carrier, so that you call Brian or you call me, and we work through it. It may or may not involve conversations with Tim and Aviva regarding ethical obligations. But in any event, those communications need to be had before we can actually move forward in the most appropriate way.
And I know, Matt, you brought this up in other programs, but it's true. It's saved us a few different times where I would recommend you call us first. Not that we're any great experts, but we do have access to experts, and we have seen enough of these that we've saved more than I can count, where there was an advance payment saved for property damage or medical payments. Anyway, the statute wasn't what you thought it was. In other words, you didn't miss the statute, which was great. But that's why falling on the sword, eventually, yes, if there's no, the communication needs to be with the client, but sometimes it's worthwhile just to take a second and bounce it off the claims person at your carrier and realize, wait, maybe I didn't miss the statute. Maybe there's a way around this. And that's the win-win that we love to see, and you and your client do as well. Anyway.
Yeah, you bet. And that's why we're here. To share whatever experience we can based on claims that we have seen. You're not alone. There are other attorneys who have been in similar situations. And we've at least had to, navigate most of them out of those situations so that we can, so that everybody can move forward. So Brian, you mentioned, if it's not a case you want, and no is a complete sentence, what suggestions do you have with respect to, the client intake piece of private practice? Are there things that can be asked, or are there things that can be done to make sure that you're properly tuned up as a personal injury practice to be able to help, sort of dodge some of these bullets?
And so in the end, bodily and personal injury has dropped out of our top 5 in terms of frequency of claims reported, but it stays strongly in there in terms of severity. So it's still a risk that costs practitioners a lot of money. And so we try to drill back down, and you say, well, how are people missing deadlines? A lot of times there are a lot of factors why, I guess. And I tried to reduce some of these to a nutshell kind of report, thinking, well, for this type of program. But so issues, intake. At the beginning, I talked about the informal intake, and I think that has to be brought up once again, where you didn't really recognize you were taking the case in because it came in on a weekend or in your neighbor's backyard. So that's an issue. Number 2 is you take the case in, and then you lose track of the client. Sometimes, I know this will surprise you, but sometimes people that get in accidents tend to move around a lot and disappear at times and then return into your lives. But the stressful call that I hate taking, and I'm taking it more than I like to, is from the insured who says, I haven't lost track of my client. I don't know where they are. I really don't think it's a very good case, but the statute's about to toll. And so I would recommend that at the time you take in the case, if by chance you can take in other information regarding their family or relatives or work, just to broaden your base as far as communication. And I realize I'm a little dating myself now from when I practiced. Now it becomes cell phones and emails and things like that, but get as much as possible of contact information, and and that's another reason why to stay in touch once you decided to take a case with the client, so you're not at the end of the 3-year term trying to figure out where they are and if you want to pursue something. Anyway, so keeping track of the client that has been a cause of claims, getting relevant information regarding all of the collectible policies. And I say that we see it even on this end in the legal mail case, where the attorney late in the game on the other side of the case first asked about, well, what are your insured's policy limits? And if it's in litigation, obviously they can be produced. And sometimes they're very disappointed because it appears they've told their client that they are looking at a much bigger recovery than is ever possible because they never did figure out. I think there's assumption, at least in the legal malpractice field, that maybe all policies are giant. That's not the case. I think maybe people make the same mistake sometimes in the auto industry. And I do think some of the burden falls on the attorney when you say, well, by the way, there's only a $50,000 policy for the first time after they've incurred $75,000 worth of chiropractic bills. That falls on the attorney a little bit. I think you could argue it is what it is, but get the policy information early and often. And if it's a policy limits case because the treatments are already exceeding the policy limit, then get the policy limit. Don't let it languish. The intake situation comes back to bite our insured so often, whereby they have a very good docketing system. It comes up perfectly when the statute looks like it's told, and then they dig in and find out, oh, this was an Illinois accident or an Ohio accident, or this was a claim against the city or a municipality or the government under the Federal Tort Claims Relief Act, the whole gamut. So the problem is that if the only review after intake is the system in which the intake information was put into, you're not going to see those nuances. And I don't know, I've seen years being labeled wrong on accident reports, medical records, birthdays being incorrect. Keep in mind, some of the data you're reviewing is was just put in by a human as well. And there are mistakes that happen. So I know this is where I get to the point of saying, busy running around the state, but maybe on a weekend, or if you get a chance, boy, take a double down, not just to your docketing system, whatever you use, but actually to open up the jacket again and just double check on the motor vehicle accident report or a medical record, or like I say, this was an Illinois accident. I mean, take another peek at that stuff so that it's not your docketing system that fails you. It's the information that was docketed, put into the system and then not noted. And I say that, it's a pain in the neck to do. I said a weekend or a night that you do it, but boy, is that a way better than paying a deductible and being deposed and having a claim against you when you were counting on a fee coming in on the plaintiff side. So the intake, I guess I think I've said what I need to say there. Staying in touch, double checking, and drilling back down to make sure that your system reflects the actual situation.
And I think probably go ahead. Okay, well, probably a good time to mention, because you mentioned nuances and you mentioned, a couple different kinds of claims, whether they're against municipalities, whether they involve the Federal Tort Claims Act. Those are all pieces that may still fit in the classic practice area of personal injury, but they are areas where you need to check yourself as an attorney and keep in mind your obligations under Supreme Court Rule 20:1.1, which is called competence. A lawyer shall provide competent representation to a client, and competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Again, it's one of those rules that we attorneys must follow that is full of gray areas. And the comments are a little more helpful. In comment 2 to 1.1, explains that competent representation, what comment 2 basically says is this, and that is that as a lawyer, you're smart. And as a lawyer, you studied a lot and you know how to issue spot and you know how to find answers. And so if you're in an area, like Brian mentioned, where there are nuances that affect the practice, study, bone up on the law, figure out exactly what it is that you need to do, and put some of that extra time into the representation so that you do it in a competent way and you don't run afoul of this rule. And, most importantly, that you provide adequate representation to the client. One of the other statements that I really like in that comment is that competent representation can also be provided through the association of a lawyer of established competence in the field in question. And what that really means is network. Find those people, those lawyers who have been there before. And I've mentioned this in previous presentations as well, that I'm a member of the Solo Small Firm General Practice section board. And one of the things that we feel is most important to provide solo and small firms in Wisconsin with are networking opportunities. And so we work very hard. The conference is coming up October 1. There's a plug for it. I'm sorry, it's later in October, isn't it, Brian? It's October 27th and 29th.
Matt's showing incompetence at the highest level.
Exactly right. Thank you for repairing my error, Brian.
Yes,
yes.
Did you say the right date for that? Because it's October.
It's the end of October. I believe it's the 27th.
Yeah, the 28th, 29th, 30th. I think.
There it is, 28, 29, and 30.
We were just doing that. That was just part of the gag to show incompetence.
Exactly. And appropriate timing is everything, as you know. But in any event, back to the point, networking is very important. And it is one of the ways that you can make yourself as an attorney competent to be able to take on cases in areas that maybe you haven't been in before, whether it involves a federal tort or a claim against a municipality. If those are things that you want to pursue, Wilmick would stand behind you in pursuing, areas of practice that maybe weren't identified in your application. But the whole point is, there are things that you can do to make yourself competent to pursue those, and keep those things in mind, as Brian mentioned early on, for when you're considering taking on a client. Brian, what about the client who has been to other attorneys before, and perhaps in this conversation you're the third or fourth in line?
I was going to say, just to leave that topic, or one last point on that, the claims against the government, municipalities, state-owned facilities, that whole thing. There's such a danger that I know some firms flat out don't take them, period, sadly, because these notice provisions are set up. Well, from my experience, the notice is not the problem. The state facility, whatever, the government knows of the claim. When the postal truck runs over someone, they know of the claim. So this notice thing is a complete farce. But it's set up to trip up plaintiffs so they miss the deadline. And I would say one nice thing, the firm I was with had a couple of staff members that were dedicated that only handled the notice claims, the ones that were against states or the government. And that's a luxury that I realize a solo may not have, but that was a nice system. Secondly, maybe to say, you know what, I'm not even going to take on these claims against the state because they are so fraught with peril. But anyway, sorry, man, it was just bothering me to think about. I hate those claims because never once have I ever had a situation where I believed for 1 second that the state or municipality wasn't aware of the claim, but you get tripped up on this notice. So it's a gotcha situation to save the state money, I guess. But were we talking about client expectations then, or what did you say?
I had asked you real quick about client intake when you're the third or fourth lawyer.
Oh yeah. Well, the biggest thing there in this area is that the clock's been ticking and there may be damage done in the claim that you can't repair. In other words, maybe the client didn't get treatment in a relevant time period, doesn't have a doctor that will help that person. So yes, you're a good attorney and you're going to do the best you can. And I know, Matt, I'm thinking of one in particular that you and I are both involved because it involved two of our insureds, but you're not a magician. And just understand that under CELTREC, and Matt, if you haven't talked about it, this will be the lead in to do so, is that if you decide to take the case and jump in at the last hour, you may be stuck with some problems that you could have maybe foresaw and helped the client better establish the case, but you may be holding the entire bag, including, by the way, when the statute tolls while it's in your office for the 1 day when the attorney before you had it for 2 years and 364 days. It's a really unfair, it can be kind of an unfair rule, but that's the risk. And secondly, and then after I finish, talk about CELTREC for a second, but the fact that the person's gone to 2, 3, 4 attorneys should give you pause. I'm not saying that maybe you're the right one for this person. That's great. I would recommend you at least touch base with the attorney before, see what maybe happened. Maybe it's the attorney was the jerk, but maybe there's something to be hands off on and not take on a problem you can't fix.
Yeah, and that's, agree. There may be a reason why this person doesn't work well with others, and specifically with other attorneys. But what Brian was alluding to is a case called Celtract, and I will pass along the site. But the Celtract case basically stands for this: if you are the next attorney in line, if you are a successor counsel and you undertake representation, even though an error was committed in your estimation or in an objective estimation by the attorney previous, and you are in a position to be able to correct that error, forget about the first attorney, because you are now on the hook for repairing that error, so that the case can continue as if the error were never committed. So be aware of that. And, that it should be, like Brian said, red flags should go up, your spidey sense should go off, however you want to talk about it. If you are, the second or third attorney, that this person has gone through, you may want to say no and have that be your complete sentence and write your non-engagement letter and be done. So, keeping time in mind here, I see that we're about 3/4 past the hour. And Brian, I wonder if we can get into some of the substantive errors. We've already talked a little bit about, missed deadlines, and that can happen for a lot of different reasons. More often than not, it can happen, we call it sort of the garbage in, garbage out theory. If you put in the wrong date of injury into your software, no matter how sophisticated the software is, it's going to spit out the wrong end date for the expiration of the statute of limitations. But there are other reasons why deadlines get missed. And then, I guess the follow-up to that, Brian, is what other substantive errors besides missed deadlines do you see? Well, the client's expectations have factored. I don't know how we ever figured this, but at least in our analysis, 15 to 20% of the personal injury malpractice claims that we have tracked at Wilmec over the years, really we trace back to failed client relations, such that, and it's a weird, in some respects, personal injury is a strange client connection, because it may, a lot of areas of the law you worked with the client and will continue to work with a client on a sale of business, and then maybe a traffic matter, and then a purchase of a home, and that you have a long-term relationship. But in the personal injury plaintiff world, often it's the only time you're going to see this client. The client really doesn't know you very well, and they feel they've never established a connection with you as the attorney, so they're not going to hold back when they think you've made a mistake to file a grievance or a claim, because they're unfortunately, and I'm being in all seriousness, because I did the plaintiff's side of personal injury, and I think there are a lot of great lawyers out there. There's a perception out there that this area of practice, somehow they don't do anything and they take big fees, and so there's a little bit of a strike against you if something goes wrong, where they didn't ever care about me and I never heard from them and all they wanted is my money idea. And how you can get rid of that is by making sure you are sending out notes, even just an email, just checking in, how are things going, hope your leg's feeling better. I mean, it sounds stupid, but it establishes that you care about them and that you're concerned about them and you care about their case. That's number one. The second piece is the puffing idea. Unfortunately, a mistake's made and the statute's missed, and the only letter they have is your demand letter that you knew was unrealistic and they were never going to get anywhere close to that. Make sure that you're having those honest and real conversations. And the second letter goes out where you say, although I demanded $100,000 from State Farm, you and I chatted and we think realistically, if we could get $25,000, that would be a great day. That's often missing when the legal malpractice case comes in, and then the client says, well, you said it was worth $100,000, and that's the only letter they have. I mean, it just makes it difficult.
So anyway, I just wanted to touch on that client expectation thing, making sure that you're aware of that. Regarding the substantive errors, it's missed deadlines by far lead the league. And number one is, how do you miss it? Practicing out of jurisdiction. We've had claims all around the country, and we only insure lawyers that practice in Wisconsin. So obviously we know that lawyers take cases that are out of state. And I think that's okay to do. I mean, obviously you're trying to earn a living, and you have a client that comes to you that they were in an accident in Ohio on their way back from Florida. You don't want to turn away a good case, but is it a good idea? Are you licensed in that state? We already talked about, obviously every state, there are different statutes in different states that you want to be aware of. And Matt's point about being competent, it's not a good excuse to say, well, I wasn't licensed in Illinois, so how was I supposed to know? You take the case, you're taking the case to handle it competently. So one of the things that may be a wise thing to do is associate with local counsel. I mean, you're going to be the contact, the client likes you and is comfortable with you, but you know what, I'm not licensed in Illinois, or I don't know how their county works, or what, there are all kinds of weird nuances that that everyone runs into in their own counties, let alone in out of state practice. So associate with local counsel, I think, is a great idea. Keep on the case, but do understand that if you are expecting a fee and our co-counsel, the client can look to you for 100% of their damages. You may try to involve the local counsel you work with, but if you're expecting a fee and working with other counsel, don't think you're not responsible for the outcome, because you are. One other little side note, I was with a commercial carrier, and one of the things when a claim would come in, often we'd look at it and you look right away and see, you get a demand letter from an attorney and you recognize, wait, they're not even licensed in the state that they're making this demand in. So I do question, again, are you best serving your client when they know you can't put it in suit yourself? Maybe they think you're just trying to get an offer, and is that the best thing for the client? That's something you have to talk to the client about. But there are times when you might honestly say, you know what, I'd love to be involved. You need a lawyer in Florida to take this case, because they're the ones that can walk across the court to the street, to the courthouse, and file a case. How are we doing? Okay, I can keep moving. Strangely, we continually see claims that involve minors, and I say strangely because you have a longer period of time to bring the claim. And I think, unfortunately, it sets up a situation where you put the matter on the back burner, and minors are one of those that you're waiting for a final medical report, or you weren't too worried about the case because you thought you had all kinds of time, and you do. But I think that it's just the procrastination piece, and it doesn't just have to be a claim involving a minor. We just have seen several of those where you think you have all the time in the world. If you're not too, whether it be a minor or a case that you just don't have a lot of enthusiasm for, I think maybe from the risk management standpoint, say the no that Matt said at the beginning, because really nothing good comes in this field of practice by waiting and by sitting on something. Either move it forward or move it on, or don't take it at all. And that's a good way to avoid missing the deadline. We already talked about the state, municipality, federal government claims. Those are out there, and we've hit that hard enough, I think. One other area that I think is a concern for this area of practice, and maybe even more so with COVID, is the whole problem with the medical profession and the PI attorneys and their clients either getting help from doctors wanting to testify or support your client's case, or this idea of there's a letter of protection guaranteeing that the medical bills will be paid, or the client doesn't understand that they do have to pay the medical bills, or the ERISA claim is now worth more than the policy limits on the underlying claim. But that's something that don't ignore and think that's going to work out at the mediation, or I would definitely recommend that be hammered out prior to mediation if possible, so you have an agreement with that medical provider or the ERISA carrier in advance, and don't have to let the defense know that. But you don't assume that it's going to clear up after you settled and then you find out you have a problem with a subrogated carrier, because that has led to claims that we have seen against the attorney for not timely handling that piece of the case. When there is a lien, I think it's worth noting that when a third party asserts a lien, like a hospital lien, for example, the lawyer has to ethically hold those funds in trust until that lien issue has been resolved. The problem when we've had this claim more than once where the lawyers disperse the money to the client, the lien really is not the lawyer's, it was the client's problem. But if there's a letter of protection that the lawyer ignores, the client hits the road, by the way, takes their money and runs, they're going to come after the lawyer and the law firm. And so it's just not worth it. Yeah, I understand the pressure to disperse the funds, but you're doing that at your peril, because the lawyer could be left holding the bag when they ignore a lien that they were put on notice of. The failing to work up a case, I think, again, I would touch back to the COVID situation. If you're not getting support from the medical providers or some type of treatment provider, that needs to be shared with the client immediately. If there's a pre-existing issue that's popped up in the records that is going to be problematic, don't make that be your problem because the client didn't understand that existed. Be upfront and forward that to your clients so they understand the maybe some of the problems that they're having and you're having in supporting their case well in advance of the statute. And then I mentioned the insurance coverage issue, and I think I'll mention it once again, is that make sure you're understanding what policy limits you're dealing with. And one thing that comes up from time to time is the failure to put the carrier on notice of your intention to take an inadequate policy on the vote notice problem, which I don't think we cited in the outline, but where you have to allow your client's carrier on a underinsured motorist claim to potentially substitute collateral. And I know this is getting kind of bogged down into the trees, but it's just an area that can trip up practitioners. And I just had one a week or two ago where the same issue came up again, where it's not clear whether the client's carrier was put on notice prior to the attorney accepting the inadequate limits on an underinsured motorist claim. And it's just something that you want to make sure you're out in front of. And the problem is the client wants the money yesterday. You're under a lot of stress and pressure, but there are times when you're just going to have to say, cool down. We got to get this straight, whether it be a hospital lien, whether it be the underinsured motorist getting the approval from the carrier. And the final thing is on the disbursement of the settlement. Make sure that doesn't become an issue where you work real hard on the case and then at the end the client's dissatisfied for things that were out of your control on timing. We pay our bills timely to our defense counsel, and when we settle legal malpractice cases, I honestly can say, having handled plaintiffs' cases, there were times when the delay was, I thought, terrible, 60, 90 days. In that time, there's some suspicions and anger and aggravation that can develop where the client thinks you're holding their money or why haven't I received my money. Make sure that that's again back to the expectations, but that you advise the reasonable time frame so that it doesn't become a situation where they're dissatisfied with what you did or didn't do in dispersing the funds.
Real quick, Brian, before Tom gives us the hook here, I just want to recognize the overarching theme here is communication. That's a big part of an attorney's job. And, whenever you advise your client or whenever a situation comes up that requires your expertise as the lawyer, I always encourage lawyers to write the IAY letter, the I advised you letter. That's always useful. It's sort of meant as a running log. And whether you're doing it in a formal letter, a memo, a note to your file, or even in your billing practices, like we mentioned in the outline, that communication is key. And it carries through to both sides of the relationship so that if there is an error, make sure that you communicate really quickly with your carrier so that you make sure that you have the coverage that you pay for in place. So that's my parting shot. And Tom, I'll turn it over to you since we've now hit our 1 o'clock deadline.
Okay. Any takeaways from you, Brian? You want to throw out?
No, I just think it's a stressful area of practice, high volume often, and the client, it's a very adversarial area of practice. So there are going to be mistakes made. That's just the way it is. And making sure your advisor, don't make the second mistake about not putting your carry-on notice if there is a problem. We understand there are going to be mistakes. We're here for you. Make sure you use us and report things timely. It often isn't nearly as bad as it seems at first instance.
All right, very good. Just a reminder for those of you that want those case citations from Matt, again, I know he gave the email out, and I think our video producer, Rick Benedict, posted it on the YouTube chat, but it's Matt, matt.beier, B-E-I-E-R, @wilmec.com. And Matt can send you the case citations. And if you have any other questions for Matt or Brian, brian.anderson@wilmec.com. Send them their way. They'll be happy to address those questions. So thanks for being with us today. Hope you enjoyed it and got something out of it. Our final Free CLE Friday with Wilmec will be November 19th, Friday, November 19th. So make a note of that. As we get closer, we will send out email notices with topics and speakers and that sort of stuff. So one more this year, November 19th. With that, thank you again. Enjoy the rest of your day and the weekend, and we will see you again at our next seminar. So long, everybody.
Thank you.